Hi, my name is Mick Harris, and I'm a real estate and business attorney here at Tonkon Torp, a leading full-service business law firm in Portland, Oregon, where we're sitting here in the lounge on a beautiful sunny summer afternoon. I'm joined here today with David Petersen and Jackson Lewis. David is the current co-chair of our business department and most recent chair of our real estate and land use practice group. David has provided real estate investment advice and development advice to Pacific Northwest families and closely held businesses for over 25 years. Clients particularly value his practical, common sense advocacy on real estate transactions, financing, land use matters, and day-to-day real estate portfolio management. Jackson has 2 decades of experience in the fields of estate planning and fiduciary administration. Jackson is in fact a former estate planning partner here at Tonkon Torp. He transitioned to trust administration 5 years ago, leading the Portland fiduciary presence of a national bank. And he is the current Oregon market leader for Northwest Trustee and Management Services, a boutique trust company serving clients in Oregon, Washington, and Idaho, with a focus on families with complex assets such as real estate. We're here today to talk specifically about family-owned real estate asset management, both the day-to-day operations as well as what happens when families focus on the transition of those assets and think about what happens in the next generation. David, to start with you, I would love to ask, what do you think is important about this topic? Why should people watch this video, and what issues stand out to you?
Well, thank you, Mick. Family-owned businesses are the backbone of the Pacific Northwest economy. Most businesses in our area have a real estate component that is a substantial portion of their company's value. And then beyond that, most real estate investment in our area is held by individual investors and small companies to generate income, both for the current generation and to generate wealth to pass on to the next generation. So there's much value to be gained for these real estate owners to understand how to stay on top of the legal and other issues that are important to maximizing the value of their real estate assets.
Great, thank you. And Jackson, how would you follow up?
Yeah, I just say that, so my company is often called into service when there's a transition that occurs between frequently when a founder dies or a real estate owner dies. And it's that during those periods of transition is when you really see the value of what David's talking about, that there's a big difference between a family that has been very attentive to the kind of details he's talking about versus a family that has toddled along without the team that they needed to pull together, and it can affect the value of the real estate.
And to that point, whether they've been carefully and closely managing it or sort of operating in the background, that type of asset management is not static. And over time, as these transitions that you're talking about occur, you see different changes in ownership at different stages, and those surely change over time. As you witness that process, what are some of the pain points, best practices you've seen, things like that?
Sure. So it's interesting. An important thing to understand about a family real estate holding is what role the real estate plays in the family's overall portfolio of assets. And there are a couple of typical configurations that we see among our clients, and I'm sure your clients. You see there might be real estate as a significant holding, which really supports an operating business. The family is involved in the operating business, and that's their primary wealth generation machine. But the real estate might be warehouses or the actual facility in which the business operates. But the real estate essentially serves the operating business. Another type of ownership is where the real estate really is the wealth generation machine. The owners are experts in the buying and selling of real estate, and they might be, these assets might be more leveraged, they might be positioned with more risk, they might be more concentrated, where the real estate really is the majority of the portfolio, because the plan is that real estate will eventually generate the wealth. There's another configuration that's pretty typical, which is the real estate is more of a passive income generation asset, where the value to the family is its ability to generate a reliable stream of income, much like an annuity, and support whatever goals the family has for their lives. And then lastly, I'll say, because this is, I'm sure we've seen this in our clients, sometimes the real estate is really the vocation of the first generation, where it's what they built expertise in it and they love it. It's really their life's, it's what they're building is their life's work. And that the next generation may or may not share that passion, and many times does not. So.
Wonderful, thank you. So Jackson just talked about 3 or 4 different types of real estate asset scenarios. One in which perhaps the real estate is literally underlying the business operations, one in which the asset is a key and critical component of the investment portfolio, one in which there is a continual stream of revenue that's being generated, much like an annuity, and perhaps a fourth where there isn't clear necessary financial value, but there may be more intrinsic or emotional family value. Thinking about those different types of scenarios, which must each pose both similar and sometimes very disparate legal considerations, what are some of the day-to-day ways that you advise clients, David, about these various types of holdings?
Yeah, so I think that a lot of clients that own real estate think that they need a lawyer really only when there's a transaction involved. And that's really not the case. I mean, certainly it's important to have a lawyer when you're doing a transaction, whether it's a buy or a sell or a finance or a lease. But both at the initial acquisition stage for family-owned real estate and on a day-to-day basis, there's really 2 important issues to consider that I think are often overlooked. The first one is title. Whether you're holding property, and there's various ways to hold property that each have their advantages and disadvantages. You can own it in your own name, you can own it through a trust, you can own it through a business entity like an LLC. But what I have found is that over time, over the time of like a generation, title sometimes starts to diverge from what people understand it really is. And so when things get messy, particularly as property ownership changes generations, it becomes more time consuming and expensive to fix it when you do ultimately come to the transaction stage. So what I like to see families do is to really understand how they hold title to their property, what the benefits are of each of those ways and what are the disadvantages, and to make sure that they're keeping up with changes in their family. So if certain family members are coming in and out of the business, to make sure that they are that the ownership structure is being documented to match that. Similarly, if somebody passes away and there's an inheritance, to make sure that you understand who the next generation is, what they own, and how they own it. When title is uncertain, you're going to create unintended consequences, usually related to tax, related to potential environmental liability, and with respect to other kinds of liability as well. For families that use their property in the operation of a business, which is one of the ways that Jackson mentioned, it's particularly important to silo ownership of the property separately from the business assets, whether that's just through a different entity that maybe has the same ultimate owners. That helps protect the business assets against potential liability related to the property and vice versa. Another day-to-day issue that's often overlooked is lease management. Leases are often long and complicated documents, and they have lots of duties and obligations of the parties, and they stick around for a long time. So there's more to a lease than just paying the rent and maintaining the premises. So a sound strategy when your real estate asset is a lease, whether you're the landlord or the tenant, is to make sure you understand your duties and, most importantly, the timelines associated with those duties. Because if you don't, you can have some significantly adverse consequences. And so what I see a lot is things like, for example, a party's lease has expired and they don't know it, or they missed an opportunity to extend the term for a lease that's particularly important to a business, or even the property has been sold or the identity of the tenant has been changed and they haven't kept up with that on a day-to-day basis. So these are the kinds of oversights that having legal counsel on a day-to-day basis is going to help you avoid.
Thank you.
And I'll add to that. It's generally much easier to make those changes while everyone necessary is alive and it, has at least a sense of the history of the property. It's very difficult when you're walking into a storage room full of bankers' boxes of documents and trying to recreate that over a, 10 or 15-year period.
Yeah, and there's a practical aspect to that too. I mean, if you have to solve a title problem that arose 30 years prior, the people may not be around, the documents may not exist. It may not even, you may have to do an error search to find out who are the heirs of somebody who passed away 25 years ago. It can really be troublesome and time consuming. And if you just keep on top of that, then you're in a better position to have efficient transactions at the times you need to have them.
Great, thank you. So then in the spirit of avoiding troublesome, time-consuming, and expensive legal fee incurring scenarios, what are some of the points when you're advising clients in their transition planning? What are some of the points you try to make sure they're thinking about and getting ahead of to ideally end up with a smooth transition, avoiding some of the pitfalls and challenges to untangle that David just outlined?
Sure. So, my team is, we are a fiduciary administration company. We manage trusts for families. And one of those transition times is death of a family member, right? That's sort of that's 100% likely to happen to every single one of us. So it is a transition a family is going to have to face. And when they face that transition, they usually have the option to plan for it with the help of wills or trusts or estate planning documents. And those documents are a great general strategy, but they should be tailored to meet the need of the real estate. And the way I think about that is it's basically who owns it and what do they own, right? And in terms of who owns it, what we're talking about is who is making the decisions with respect to the property. Again, if we have that founder who's deeply knowledgeable about the real estate and is an expert in its management and helping it grow and all that, when that person is gone, it may make sense to, there's sort of a couple categories of typical owners that you might plan for. If it's an operating business, if the real estate supports an operating business, you might have someone in the operating business at least have some ownership or some sense of control over that, because the relationship between the operating business and the real estate may be essential for the health of the operating business. Again, the siloed ownership is a good idea. I think you can achieve both those things. You might choose to have a family member become a trustee or otherwise have management responsibility, especially if that family member has expertise in the family business of real estate. You might choose, sometimes people have trusted employees or management teams that they've worked with all their lives. And those folks can be vested with authority in various ways. Again, the idea is that the owner is planning when they are no longer there to make the best decisions for the business. Presumably, you want the team in place that can make those decisions. And then lastly, you might have an independent trustee make those decisions. And that is particularly valuable where notwithstanding the expertise that may have accumulated in the family, there are family dynamics at play that make it possible that, decisions detrimental to the family might be made just because we all have families, right? We all know how that works. So sometimes it's helpful to have an independent third party make those decisions, who's able to retain outside experts and do whatever they need to do to make sure that the decision benefits the beneficiaries of your estate plan.
Great. To your point, sometimes family dynamics can feel quite out of control, but largely what both of you are talking about are considerations that hopefully are within the control of especially the first generation owning parties, whether it comes to good documentation, thinking ahead, ensuring that you have transition planning in place and a relationship between, to the extent that there's underlying real estate and operating business, those two entities. But there are also conditions that sometimes are quite out of our control. For example, market conditions. And here we are coming out of a pandemic, dealing with unprecedented commercial real estate upheaval, particularly in certain larger metropolitan areas. How does the current state of the commercial real estate market impact how you advise clients with respect to the issues that we're talking about? David, do you want to start?
I think that one of the mistakes that a lot of people make is to make assumptions that the way things are the way things will always be. And you can probably cite no better example of that in our history than over the last 5 years in the existence of the pandemic and the impacts that that's had on the commercial real estate market. If you were to take the Wayback Machine to 2019, what you would find is you're in an environment with extremely low interest rates, easy availability of capital from lenders, and a relatively robust development market. And what are they building in that development market? They're building apartments and they're building offices. And fast forward just a few months, and all of us who work in an office are stuck at home, working at home full time. And then as the pandemic eased, we transitioned into part-time work. And it looks like part-time work is going to be an important component of how we work in this country going forward. And if you have made assumptions back in 2019 that the demand for office space was always going to be the same as it was, you're going to be in a position to, you're going to be in an unenviable position where you have possibly straitjacketed your decision makers that are managing your family-owned real estate in a way that makes it more difficult to adjust and go in a different direction.
Wonderful.
To that point, so it's another area that people should think about when they're planning for transitions. As I mentioned, there's, who owns it and then what do they own? One of the things that families are deeply concerned about is holding on to the assets. These assets have been the golden goose for the family for a long time, and so they might desire to retain those assets even when the founder is gone. And that's an interesting, if you die and your assets come under the management of a professional trustee, they're subject to something called the Prudent Investor Act or Prudent Investor Rule. And one piece of that is that it can require diversification. So in that case, you might have a trustee who's obligated under their rules to essentially diversify the portfolio. That may be not what the family wants. The family is able to essentially require the trustee to hang on to those assets, to retain the assets. And that's a good planning. There are a number of ways to do that. You can do it by, just giving the trustee the authority to hold on to the assets. You can direct the trustee to hold on to the assets. But if you do so, then you potentially run into the issue that David's talking about with, the world as it looked like when you made those plans may look very different when those plans take effect.
And I would say conversely to what Jackson's talking about from the lawyer's perspective, we really appreciate it when there's somebody like Jackson who's involved who may not have the emotional attachment to the asset in the same way that the family does, and can provide really sound advice, sound business advice, and a bit more of a dispassionate evaluation of what might be the best course forward to meet the needs. I think a lot of people have maybe they understand their needs and they can express their needs, but they make certain assumptions about how to achieve those needs that are based on incomplete information. When you have somebody like Jackson involved, they can provide you a much broader picture of what your options are.
David, what if people don't do what Jackson's advising and fail to plan accordingly?
Yeah, so the potential downside, I think, that is going to be obvious to most people is an intra-family dispute. And that's obviously a risk, right? Families have additional dynamics that may exist in addition to the business dynamics. I think Jackson touched on that a little bit. And that's always possible, particularly when family members may find out that they have an interest in something that they didn't know they had, which quite frankly is more common than you might expect. Heir searches and things, and the death of the patriarch or the matriarch turn up people that maybe didn't know what they were involved with, and they see that the golden goose has come along and perhaps are inclined to muck up the works. So that's certainly a possibility, but there's other less obvious risks. One I touched upon in my previous answer, which was about how title problems can create friction at the transition points. As I mentioned, if you need to basically resolve an interest of somebody that was created 30 years ago, finding the people or the documents or the information you need is going to be difficult. That's also true if the party on title is a trust or an entity, the trustee may not be able to be found. The appropriate authority for the entity to act may not be able to be established, and you may end up with a court action where you're seeking to quiet title to a piece of property to clarify how that title is, so that steps can be taken to realize on the asset. All of those things are going to slow down transactions, are going to frustrate people, and are possibly going to lead to interfamily friction. When the asset is owned in a business, then you've got additional timing considerations, because of course the asset is needed for the business. And if it gets tied up in a quiet title action or a probate, that's going to be counterproductive to keeping the real estate in a position where it's being suitable for the business. You know, if it's a property under development, that's even worse because it's under construction. There's an active hand in management is needed, and it's bad for it to be tied up in some kind of property dispute. Better to have either a plan where the next generation, the next person who's going to be running the property knows what to do, or there's somebody like Jackson, a trustee involved, who can make those decisions on a timely basis.
Two points I'd add to that is it is an example of when that works well is when the family has a clear understanding back to those sort of configurations of what role the real estate plays for the family. That really can change, especially upon the death of a founder, and all of a sudden maybe the operating business is going to be sold and the real estate is no longer beholden to that business. And that's that is an example of a very clean transition where you know, the real estate served one purpose during life, and then at death, when it's siloed like that, the real estate can remain as that annuity-like method of supporting family members who are not involved in the business. The operating business is sold, and it provides the diversification component of an overall.
Right, very common. Where the family business is sold, and you transition from owning real estate to support a business to becoming a landlord, a passive landlord, which provides income like in the form of an annuity or similar. So that's an excellent example of how if you've planned ahead for this, you can make it a lot more smooth and streamlined and easier for everybody, and avoid unexpected detours into court.
The second point I make is that, you know, as much as my job is made very easy when there's a good estate planning attorney involved, but when the family owns real estate, that's not enough. You need an attorney like David who has who can make sure that all the collateral documents that are so important in running the business of real estate, the operating agreements, the buy-sell agreements, you know, all these documents that become so important at when any transition occurs, those have to dovetail with the estate plan.
Well, I really appreciate all of the wisdom that you shared today. If there's any takeaway, it's that perhaps death is inevitable, but thorny transitions and failing to plan ahead is not. Is there any final thoughts either of you would like to share?
No, I've had the pleasure of working with David in the past, and I will say that he's a great member of a real estate team.
Yeah, I would say the same for Jackson. I'm glad to have him as a resource for our clients as they try to build their own empires.
Wonderful. Jackson, David, thank you both.
Thank you, Mick.
Thank you, Mick.